Good morning, Mr. Borbo.
Good morning, Chief Justice Marshall, Associate
Thank
Justices. May it please the Court. I am Mark Borbo, attorney for Boston Edison Exelon parties. It's a little unfortunate that the caption of the case, while it's Boston Edison Company, in some places it shows up as Exelon. Edison has brought the action partly in its own name and partly in Exelon's name under contract. Exelon was an affiliate, for this purpose, an affiliated entity in the land and the subject matter of the case. And I think I'll start with that. I think it's very important to get the context set in the beginning and to remember that this is, it may have some complexity. It was a long trial. The jury was out a while. But in its heart, this is an eminent domain case. It's an ordinary eminent domain case. It's subject to the ordinary principles of eminent domain that the public has an absolute right to take, but the right must not be visited on the landowner out of proportion to that of the public generally, that all damages that flow from the public project, from the takings that are made for the project and from the project itself, including all incidental damages, are to be paid in compensation to the landowner for the taking, and that the property is to be valued in the usual sense, and this is a usual case in this way, for its highest and best use in the marketplace. And
but that highest and best use has to be a use that has been initiated and is something that actually exists, doesn't it?
Well, the highest and best use actually, the case law strongly supports the idea that the highest and best use is that use for which the market would value the property, and that is any use that has a reasonable probability of coming to pass. It doesn't have to be legally possible at the time of the taking. It simply has to be something that was reasonably probable of being permitted, either for zoning or Chapter 91 in this case, in fact, there's even cases that say that part of that reasonable probability, if the site could be developed and it required the buying of some additional land for access, if that was reasonably probable, and the plaintiff could prove that.
But for example, if the land wasn't zoned for a particular use,
right,
you couldn't claim that use, could you?
No, you absolutely can claim that there's a reasonable probability of a change of zoning, that the public bodies, and this entire case was tried on that theory, yes, that the current zoning wasn't the determining factor. The current zoning of this land in North Weymouth was, in fact, industrial. No question about that. But it is very clear on the law, long series of cases, that it's a reasonable probability of a change in zoning that counts.
But it's a little harder to show, it's at least a little harder to show that you have a reasonable probability of a change in zoning than you do of getting permits and subdivision approvals for land that's already zoned for the kind of thing that you want to get. Oh. And tell me why in this case you established a reasonable probability of getting a change in zoning and including legislative changes for the things to be designated. I thought it was DPA or some certain legislative maps.
I suggest certainly that's a very critical point on which I agree, Justice Spina. It's not an easy task. It was, in fact, a difficult task, and we put on a very strong, well-developed case in accord with the standards that this court has articulated, among others in the Roach case, that in terms of the change in zoning, and I don't agree, though, that the legislature was required to make any changes, and I'll come to that in a moment, but just to stick to the zoning part of it. The plaintiff put on evidence from Mr. Robert Daler of Daler Consulting, a longtime land planner relied on by many bodies in the Commonwealth, including the Attorney General in many eminent domain cases, some of which I had the privilege to represent them on. And he embarked on and did a study of the zoning changes in Weymouth going back to 1971. The initial taking was in the year 1999. And he actually took that study and looked between 1971 and 2005, the year after the final taking. There was a series of takings in this case from this property as part of the same project. And Mr. Daler's study indicated, and he testified about it, that there were 199 parcels of land in Weymouth that were changed in zoning in that period of time from industrial to residential. There were also some other factors. There's a series of factors that the Roach case looks at as some of the ones that may be informative on this. I don't think there's a requirement that everyone has to be met. And in fact, the judge looked and specifically found, both on the motion in limine and in the trial, that certain specific factors had been, and he pointed that out, that they were, among others, that the north parcel, part that the change in zoning would need to apply to in this case. There are two parcels north and south of Route 3A, total about 78 acres, about roughly half and half. The parcel north of 3A is the parcel that this change in zoning argument relates to.
Mr. Boerbo, you know that Ms. Tillotson has said that, pointed out that you hadn't taken steps to initiate a rezoning of the property.
Well, it's not actually, it's taking steps to rezoning. The cases don't require an application. The Boston Edison Company, the plaintiff, had taken steps several years before the taking, beginning in the testimony was 1993, to hire consultants to give a redevelopment plan for that particular parcel. And by 96, they had received a consultant's redevelopment study that proposed this mixed-use type of development on the site. And the consultants were Meredith and Grew and Rizzo Associates, very experienced companies in developing property.
So when your sister says, at the time of the taking, neither Beko nor Scythe nor Exelon had taken any actions whatsoever to explore, initiate, or otherwise set in motion the process for rezoning the north side of the site from industrial to residential use, nor had plaintiffs sought legislative action to remove the site from the DPA in order to permit residential development. That's not correct.
Well, certainly hadn't sought any legislative approval, and I suggest it's not necessary. I suggest it's an overstatement that the part that as to whether the BECO had taken any steps is incorrect. They had taken steps. They had not made public filings, but a couple things happened in between getting the study and the taking in 1999 that initiated this project as far as the taking and vested the rights of the plaintiff. And that was two things. One was that the state legislature passed the energy deregulation bill requiring bodies like Boston Edison to either do generation or transmission and not both. So they had to somehow, they decided to dispose of the property but keep the transmission parts, which complicates the case a little bit. And so that's how Scythe came into it, Scythe that became Exelon, to generate the power there. And the second thing is the MWA project started to become very real. There'd been some discussion about doing this project for some time, but by 96 and 97, around the time of the redevelopment study, that's when the MWA starts having meetings saying, we've got to have this land. In fact, Boston Edison asked MWA not to take the land so they could develop it, and they were told, and the testimony was, that we have to have this piece of land, and we have to go across this property. So obviously they didn't then make futile applications for zoning approval. It's very, very costly to do a development like that. So I suggest that the cases in the law doesn't require that they take affirmative steps to actually apply for something that's futile at that point. They're getting letters before the taking that they have to reassure the MWA that they can get their building off, for instance, on the south parcel, out of the way of the plans that MWA has already put forward. That's another issue in the case here. But there was strong evidence that there was a reasonable likelihood of a change of zoning. The judge found...
Is that a legal opinion or a political opinion?
Political opinion. The reasonable probability is actually a factual determination for the jury to make. The judge has to be a gatekeeper and decide there's sufficient evidence for the issue to go to the jury. Here, the zoning, and there was testimony about what it was put forward and argued by both sides to the jury. And the jury actually answered a special question as to whether or not, that's the judge, not only did they give a general verdict, but they answered a special question, specifically, on the evidence that's presented to you, have the plaintiffs proved by a preponderance of the evidence that it was reasonably probable that the north parcel could be rezoned for residential use, notwithstanding that the property was zoned for industrial use. The judge was very careful throughout the case to make sure that that was properly instructed. While we object to another instruction, that one is correct, and he asked a special question about it. And the jury answered that in the affirmative unanimously.
So is the issue before us a legal one as to whether the instructions were in error, or is the issue whether the evidence was sufficient as a matter of law to permit the jury to make that finding?
I believe, that the question from M. Gabourey is, there's not enough as a matter of law. You didn't prove that, even though the judge found there was, and I suggest that's a discretionary finding. That's based on, looking at the evidence there. Unless there's an abuse of discretion, I suggest that this court shouldn't act to disturb the trial judge's decision that there was a sufficient quantum of evidence. And the judge pointed to, and he made a written finding on the motion in limine that's, I'm sure, included in the materials, but he made findings that there were specific support for the development history. He looked at the parcel's shape and topography and suitability. The development history on the entire east coast of Massachusetts, from Everett all the way to his testimony by plaintiff's experts on the motion in limine hearing about how properties all the way from Everett down to, I think, Plymouth had been redeveloped on the coast, had been redeveloped from industrial to mixed-use residential. He looked at Weymouth's desire in its planning documents to actually, this site was actually identified as one for a mixed-use development, and I think they call it a gateway site to Weymouth, that industrial that it was zoned for. The town, there was a history of the town trying to direct that to other areas of town and wanting to get industrial traffic off the town roadways. There was also...
But I take it your view is that, yes, whether you may concede this or not, that it's difficult to show a reasonable probability of a change in zoning, that you at least offered enough evidence to warrant a jury making that finding.
Absolutely, and we argued it, and I suggested...
The jury made the finding.
The jury made
the finding, and that's what they're supposed to do, and they took 10 days to decide this case. This was the longest civil jury that I ever had in an eminent domain
What
case.
about the argument that the experts used other properties, as you indicated, and didn't use the area around Weymouth?
No, but they did. The study of 199 parcels in Weymouth. The closest one might have been a couple of miles away, but 199 parcels in Weymouth rezoned over that period from industrial to residential, and there was only a trivial number of parcels that went the other way, because it was clear that Weymouth was directing its industrial development into industrial parks closer to the highways to get traffic, and the documents suggested that. That was all before the judge, and that also this site had been identified in planning documents.
Can I change your focus for a minute?
Absolutely, Justice Breyer.
I may be misunderstanding what Chapter 79, Section 12 says, but on page 20 of your brief, you quote it and you highlight certain language. There shall be included damages for all injury, as I say out loud or louder, to the part not taken caused by the taking or by the public improvement for which the taking is made. I read your highlighting as something of a distortion of what the statute really means, and that what the statute is really talking about is harm caused to the remaining portion of the land. But I'm interested in the predicament that you have about having been told you better move the switching station or else. Could you explain why that's covered under the statute?
Well, I suggest that the cases say that all incidental benefits, all incidental harms, damages. Roman Catholic Bishop of Springfield, there was a highway built, no taking, no damages to the plaintiff, even though the plaintiff's property, the Catholic Bishop of Springfield, got damages from the noise and road and such that made their school, it was a school, more difficult. But because there was no taking from them, they got nothing. A couple of years after the highway was built, the highway caused a little drainage problem on the Catholic bishop's property, and the highway department then made a tiny taking for a drainage easement to deal with that drainage problem. This court said that as a result of that little taking, because all incidental effects, now they get all the damages from the highway that was originally built, all the proximity and noise and any damages from the highway, lights coming into the classroom and needing to have, whatever they might be. So this is to do with the switch house issue.
Yeah, it's a switch house issue. How does that fit into the...
Well, what it fits into it is that the question there is, BECO spent over $7 million of trial testimony to move its switch house in anticipation, reasonably anticipated under the Kane case, the appeals court Kane versus Hudson, to anticipate the MWA easement that would require it to be moved.
This is for a construction easement, essentially.
A construction easement.
So why didn't you force the issue and make them go to a taking? Why didn't you...
Well, they did. No, eventually they did. But what happened is they gave plans in 1998, the Metcalf and Eddy plan that's at issue in this case, that showed that the easement was going to brush the side of the switch house. And also because it limited the area for the new power plant to be built, the building had to come down. And in fact, MWA even wrote, entered into evidence. The judge refused to allow the Metcalf and Eddy plan in initially because it was never taken that way. It was taken differently. So, but then the evidence was put in that the MWA had written to the BECO saying, you've got to live to the 1998 plan and assure us you can get your building out of the way. And
because there was a construction easement.
Because we're going to need that land and we can't do our project if your building is there.
But did they do the taking?
Then they did the taking, but slightly different easement that wasn't, the evidence was, might not have required the building to be removed, but it was already removed at a cost of over $7 million.
You know that the MWRA says that evidence should not have come in.
It was denied initially after the letters were put into evidence showing that MWRA had demanded that BECO comply with that plan in advance of the taking actually being made as they were scheduling it. After those letters, the judge allowed it in, and that's the part that I complain about, but with the specific limiting instruction that he was allowing it only for the history, that it could not be used for damages, that the only way that the plaintiffs would be entitled to damages would be those that flew from the taking that was actually made in 2003.
Would you have had to have moved the switching station even under the influence of the taking that actually was made for the construction easement because of the way you would not be allowed to use the land that abutted the
There was
switch
not
house?
evidence that it would have to have been moved under that circumstance, Your Honor.
Okay.
There was evidence, presumably it would have required some restructuring of the power plant because you couldn't fit both of those in the little area left to them. And, the MWA, if they didn't get damages from moving the switch house, but the switch house had been left there, they might have been facing a suit for squeezing the power plant and making it smaller and fewer, megawatts.
But your sister contends that the jury found, as a matter of fact, that the change in switching station had nothing to do with...
Well, they didn't. They found that there were no damages from the moving, that it didn't cause them to move it. The actual taking that was made. But that was how the judge instructed them in the special instruction during the trial.
If the cause was something other than the taking, why are you entitled to damages?
Because it's the project for which the taking is made, the incidental effect. The project said, here's where we're going to take. This is a very sophisticated, high-value project with a lot of elements being pushed around to be done at the same time.
Could they have waited until the easement was actually made?
They couldn't because the MWRA told them you can't wait.
Yeah, but
we got to have it out. But here's the reason: the power plant had to be built.
Where did they get the authority to say that?
Well, one might argue I wasn't representing them at the time, and I might have taken a different tack on it. But the fact is, they chose when to stage their takings. But their first taking was in '99. That's where the taking vests, and that I'm going over time, so that applies to the interest issue. But it also applies in this, that's with the date of the taking vests, and all damages flowing from the public project vest as of that day. It doesn't matter if the project damages happen before or after that. Subsequent takings, I say, are essentially damages from the public project as well as takings. So the plans that the public project had as of the date of the first taking in 1999, which included at that point the Metcalf and Eddy plan, the one that we say would have required the moving of the switch house, and which the jury was not allowed to consider for that purpose. I'd say that plan was part of the public project. The MWRA, by waiting, took the risk that that they would have to do it in some different way, and they could have had a risk of having to do a greater taking. As it turned out, because of the way the power plant was built, they could make a little less taking there, and that got worked out later. But they staged their takings. They could have chosen to make them all in the beginning, and if they had, I suggest it would have been the Metcalf and Eddy, because that was the only plan extant at that time. And it was only after
Mr.
PICO
Bobo.
removed the switch house. Yeah, I appreciate that, Your Honor. And on the rest of it, I have a very well-developed brief, and I'll stand on that. I
Thank
really
you, Mr. Bobo.
appreciate your kind care and attention today. Thank you.
Good morning, Ms. Tillotson.
Good morning, Your Honor. Members of the Court, Diane Tillotson arguing for the Massachusetts Water Resources Authority. Under the Fifth Amendment of the Federal Constitution and Article 10 of the State Constitution, the plaintiffs in this case are entitled to just compensation and reasonable compensation, nothing more and nothing less. Our cross-appeal addresses the issue of whether or not the trial judge committed error in, first of all, admitting the plaintiff's hypothetical development plan when there was absolutely no site-specific evidence that there was any reasonable probability of overcoming the site constraints, both with respect to the zoning, the site was zoned for industrial purposes, or with respect to the fact that the site was located in a designated port area.
Now, why do you need such intense evidence in this case? Because you don't always have to have a plan, do you?
Your Honor, it's not the question of whether or not a plan is necessary. It's whether or not there is any evidence that is specific to this site that the plaintiffs or anyone has taken any steps whatsoever to either rezone the property or to get it out of the designated port area.
Let me ask my question differently.
Sure.
Is your argument because that the use for which they were proposing to base their highest and best use absolutely not permitted under the current zoning?
That's correct. It's neither
so
permitted under the current zoning nor under the applicable regulations, CZM and
But
DEP.
you don't contend, do you, that if it was something that they could have done by special permit, that they would have had to have taken the steps that you're now saying that they did not take?
If it was permissible by special permit, given the standards for granting a special permit, I think the MWRA certainly would have had a much less strong case than we have this morning before the court. So I think you're absolutely correct that the absolute prohibition under both the current zoning and the DPA regulations is what makes this case so remarkable in that there had been no site-specific evidence.
Are you saying that they had to have made an effort to rezone the area?
Either they had to have made an effort or there had to have been something that was site-specific. For example, in the Roach case that was cited by both parties here, that was a case involving the city of Newton. In that case, the court determined that the rezoning to commercial or office use was permissible because, number one, the site was located on 128. It would not be suitable. The City of Newton's redevelopment authority had a report that addressed this specific site, not all the other sites in the area. And the evidence was admitted that the site was actually rezoned after the taking was made, and the court said that they could look at that.
Ms. Tillotson, as you heard Mr. Bobo, that I mean, one argument they make is it was futile at that point to do it because of the MWRA's actions. Now, you can quibble whether or not the MWRA had acted formally or informally, but one can almost take judicial notice of what was going on in the Boston Harbor, and the MWRA had identified this site and said, this is what we have to do, and by the way, we're under a court order from the federal judge. I mean, it seems to me that the MWRA wants us to ignore what is going on here.
Your Honor, we certainly don't ask that the court ignore what was going on, but I think what is critical in this case, and that what distinguishes this case from every other case, is the fact that the plaintiffs took no action either before or after the taking. And remember that the evidence that they submitted in this case, and you have this in the record, that there before the taking, the highest and best use was for residential purposes, and after the taking, the highest and best use, albeit on a reduced footprint, was for residential purposes. Yet, despite that fact, despite the fact that they said, well, we can't use it, we can't put 350 units, we can only put 200 units, they, in 8 years that transpired between the taking and the time of trial, they didn't take a single step, which leaves you open. And I think the question that this court really needs to address is whether you can rely solely on the opinion of an expert that's not tethered in any way to the facts of the specific site.
So your argument is that not only are their plans speculative, but they are in contradiction of zoning and other requirements, and they haven't acted to get those revised in their favor.
Yeah. They haven't acted, and neither has any public authority. The zoning, the Daler affidavit and the Daler testimony that is in the record in this case, it's 30 years of history of rezoning. None of the rezonings are anywhere close to this parcel.
I understand your argument. I find it, it's not as straightforward to me at any rate, because I think clearly what you do is you get an expert, and an expert will testify appropriately about the highest and best use. You know, meanwhile, you're facing an eminent domain taking, and it's, I mean, you're asking, I know what you're saying, tethered, it's got to be this site, and so on and so forth, but it's not so clear to me that that's the only way you can get to highest and best use. If you show, for example, that there's an extensive pattern and practice that this particular town will act in this particular way, there appears to be no other prohibition, why are you putting on the landowner the burden of taking what may be futile steps? You look afterwards and say, well, you didn't do anything afterwards. I don't know why a landowner has to act within your time frame. This case could have gone to trial in 1 year.
That's true, but it did not. I would
I understand that, but I mean, we don't look, the court delay is not, it can't become, just because we can't get to trial quickly.
Yeah, I don't think it's my client that is putting this burden on the plaintiffs in this case. I think this court placed that burden on the plaintiffs in the Skyline home.
Very fact-specific cases. And here, that's why I say you're sort of ignoring what's going on. There's a taking here, and you get an expert, and the expert looks at Weymouth and says, the fact that this isn't zoned for residential use is not a barrier to a determination of the highest and best use.
And most respectfully, Your Honor, I agree with that, but this court has said in Skyline Homes that merely having an expert, because that's what was presented in Skyline Homes, the notion that the site was suitable, according to the expert, for the use proposed, and there were all kinds of calculations presented, similarly as in here, and the court upheld the judge's exclusion of that evidence based on the fact that just a site's suitability for a particular use does not necessarily mean that they have established the threshold that they need to be able to establish to get the evidence in, number one, and to get to the jury, number two.
But why doesn't their expert testimony to the effect that we probably could have gotten a zone change through, based on the history of the changes that had occurred in this town, to satisfy the Skyline standard?
Your Honor, most respectfully, the expert testimony does not, because the Skyline's home standard, again, required site-specific information. If there had been even a shred of evidence, for example, if some of the rezonings that the plaintiff's expert relied on had been adjacent, had been industrial properties that were north of
Why do you want
Route
adjacent?
3A and adjacent.
Why do you want adjacent? I mean, I don't know whether the evidence supports, but I just heard Mr. Bourbeau saying that what Weymouth wanted to do was get the stuff closer to the traffic, whatever, Route 3 or whatever it is, you know, and that's what you can discern. And an expert comes in and says, look, I've looked at all these decisions, I've seen what the argument is, and this is consistent with that. It doesn't have to be adjacent.
I would definitely agree, Your Honor. That's just one thing that could have been in there. My argument is there was absolutely nothing related to this site. And the notion that there was a plan that suggested this site was appropriate for mixed-use development, that's all well and good. But mixed use does not necessarily mean residential.
I understand. Are we looking at this under an abuse of discretion, as an admission of evidence under an evidential standard?
Initially, Your Honor, yes. In terms of the admissibility of the evidence, yes, I would say that that's the case.
Do we look at this issue in terms of the reasonable buyer? This is a fair market value in terms of a reasonable buyer, correct?
Correct.
And would a reasonable buyer not look at a property like this and say, I'm aware of comparable property in the Commonwealth where they've been able successfully to obtain rezoning, and include that probability in the buyer's calculus as to what the fair market value is?
With appropriate discounts, Your Honor, for the fact that there was nothing imminent. And that's the other piece of the Skyline
Well, there's a
case.
difference between saying you can't let it in and you can't let it in without a discount. That's
Well,
a challenge to the expert testimony, isn't it?
I believe, Your Honor, that even to allow the expert testimony to come in, there has to be some evidence that
No,
there
I
was
understand that,
an
but you
imminent change.
Yeah, but you just answered Justice Gantz's question, yes, with discounting, and then I'm saying, well, that's when you cross-examine Mr. Coleman or whoever the expert was, right?
Correct.
And in this case, were there instructions that said if you answer yes to the reasonable probability, then they get the highest and best use? Or was the instruction, if you say yes, you may consider that probability in evaluating the likelihood of obtaining highest
I
and
believe the
best use?
court's instruction on that was that if they found that it was reasonably probable, they could consider the experts, all the testimony with respect to damages.
So the jury was allowed to discount for the probability of that result emerging. The jury was not told, if you find there's a reasonable probability, then you must treat it as if it's a mixed-use development. But I gather they were told you may consider that possibility in the evaluation of fair market value.
Well, the jury was told that they could consider the evidence, all the evidence presented, and with all due respect, the only evidence that was presented to the jury was either valuation on the as an industrial use, which the MWRA presented, and valuation as a residential / mixed-use development.
But did you ask for an instruction that said that the jury should consider the likelihood and discount the value appropriately? Since, I mean, if I'm a buyer, I would.
Yes.
You asked for that.
I believe that instruction was requested, and I believe actually that it was given.
Oh, okay. So
in the
you
context.
got that instruction.
Yeah.
So that the jury, I take it, could have concluded that there's a 51% probability that they could have gotten a zone change. You know, we think that if they had gotten the zone change, you know, it might have been X dollars, but we're going to discount it by 49%. Nothing prevented the jury from doing that, did it?
Not that I'm aware of, Your Honor, certainly. But and again, the issue from our perspective is not only did you have the zoning issue, which required a legislative action, you had the designated port authority issue. And it should be clear from the jury instruction, the questions that the jurors asked during deliberations that are part of the record, that question dominated this trial and dominated the jury's questions.
Could you address the switch house issue?
Certainly.
And the construction easement in particular, why wasn't it enough that during the course of negotiations there's an anticipation that there's going to be a construction easement, and they say you got to move the switch house, so they moved it?
Your Honor, I would respectfully suggest that that is not what the evidence shows. The evidence shows that there were discussions between the MWRA and the landowners. The property was sold to the plaintiffs, the Scythe Exelon entities, in May of 1998. The MWRA didn't even produce the Metcalf and Eddy plan until a month after that. What the record demonstrates is that there was ample reason for the for Edison to move that switch house that had absolutely nothing to do with the MWRA's taking, which wasn't made until almost 5 years later. And there was a continual give and take. The MWRA actually bent over backwards to accommodate the needs of the landowners in this case, and actually changed the location of its taking so as not to interfere with the landowners' plans for that southern part of the property. And the jury found that. The jury was was instructed exactly the way the plaintiffs requested the jury be instructed. The special question put to the jury was in exactly the same format as the plaintiffs requested, and the piece of evidence which the judge initially excluded was allowed to go in. So the fact that the jury found differently than the plaintiff's scenario in this case should not dictate a result that's contrary to the jury's finding of fact.
They say it was let in with a limiting instruction.
It was let in with a limiting instruction that the jury could only award damages as a result of the actual taking and the public project for which the taking was made, which is exactly what the plaintiffs asked for. That instruction, to the extent it formed part of this was again a 6-week trial, was more than compensated for it by the jury instructions, which the plaintiff never objected to.
And what do you say about the calculation of interest? Where the plaintiff had, where MWRA had essentially asked for a taking to be determined, or to the valuation of the taking be determined in all instances as of, I think it was August 13th. Why shouldn't the interest be calculated as of August 13th in all instances?
Your Honor, it wasn't the MWRA's request. It was the plaintiff's request that the jury be instructed that damages be assessed as of that point in time prior to the day prior to the first taking. The statute, Chapter 79, Section 37, very specifically requires that interest run from the date that the interest vests. The interest vests on the recording, and that was very specifically entered in the record.
Now, I know you say that the legislature clearly intended this to be retroactive. Have we, in fact, held that?
This court has not held that, but it's very clear that it's not a question of complicated interpretation. But no, as far as I know, the last pronouncements on interest by this court were in Liberty Square and Claff,
So
and it was
the 2004.
That was right before the 2004 amendments.
Okay. And they haven't challenged that on any constitution. I mean, they haven't challenged the statute on constitutional grounds.
Right. They attempted to, but I think they're not pressing that argument on appeal.
Thank you, Ms.
Thank you
Tillotson.
very much.